Great. We are live streaming the People versus Isaiah Gardenhire matter. However, I do not see the defense attorney, Mr. Watson. Let me check on his whereabouts. Thank you. We're attempting to make contact with Mr. Watson.
Just got done with Judge Offel. He's logging.
All right. For anyone who just joined us, we're waiting for Mr. Watson. He was in another courtroom. He just finished and he's in the process, I'm told, of logging in right now. Okay, looks like we have everybody now. And this is People of the State of Michigan versus Isaiah Gardenhire, docket number 21-905 FC. This is the time set for sentencing. First, Mr. Gardenhire, can you confirm for me that you did agree to do the sentencing by Zoom instead of bringing you here to the courthouse?
I did.
Thank you. Mr. Gardenhire, you were convicted of 2 counts of second-degree murder. Those are each felonies and each punishable by life or any term of years. You have the right to be represented by an attorney. You are represented by Mr. Watson. And Mr. Watson, have you had a chance to go through the pre-sentence report with your client?
Your Honor, good afternoon. Yes, I have. Thank you. We consulted last week, I believe, finally having to do with this pre-sentence investigation report.
And do you have any additions, deletions, or corrections to the report itself?
Looking at the face sheet of the report, of course, Your Honor, the sentencing date is no longer the 24th of January. It has to reflect today's date instead.
Yes, got it. Anything
Thank
else?
you. Yes, Your Honor. Under the heading evaluation and plan, Your Honor. I don't see a
Yes.
page number,
There
but
aren't
in
any.
the second paragraph, last sentence, there's a change. There would be a change to the sentencing date as well.
Yes,
Thank you.
got it.
Forgive me as I page through this, Your Honor. My fingertips have been frozen in that last storm, and it's hard for me to flip the pages as quickly as I might otherwise. Your Honor, there's nothing else in the body of the pre-sentence investigation report, but if Your Honor were to turn to the basic information report,
Yes,
the last known address and telephone number that is reflected at the top right of that page is no longer an address that Mr. Gardenhire uses. So I don't know how Your Honor wants to address that.
well, the way it's described is last known, so I'm going to leave it as is.
Very fine. As far as the disposition portion, at the bottom of the page, there would be a sentencing date change as well.
Got it?
Turning to the second page of the basic information report, request a sentencing date change into the other disposition as well. There's just two spots on the basic information report that shows that.
And I got both of them. Thank you.
Thank you, Your Honor. And there's nothing more from the body of the report or the basic information report. Only challenges which I understand may be made or some agreements that Mr. Stevens and I have entered into related to the sentencing information report. Thank you.
You mean the guidelines?
That's correct.
All right, do you want to take those, Mr. Stevens?
Certainly, Your Honor. Actually, before that, though, I do have a change to the body, which would be the jail credit.
Yes,
So the timeline needs to be corrected for the appropriate scoring of jail credit. The charges regarding Mr. Gardenhire and his arrest on them occurred first on September 13th of 2021.
not September 23rd?
Not September 23rd.
Okay,
And he was held, he remained held, but for scoring of jail credit, that timeline ends on September 27th, 2021, which is when I believe he entered a plea or was sentenced in Isabella County. So that stops the running of credit.
well, it would stop it if he was sentenced in Isabella County.
And I believe
I have sentenced on November 9th.
then that must have just not. So it would end then. And then it would resume again when he entered the plea in this case, which would be December 13th, all the way till today's date. Just want to check my math.
So you're talking then about between September 13th and November 9th? Because it goes up to the sentencing on Isabella County. And then again from December 13 to today. Is that what you're
Right.
saying?
Correct.
Okay, and then did you count the days?
I'm just confirming my math for the second half. So I have 57 days for the first period of time and 77 days for the second period of time, for a total of 134 days.
Do you agree with that, Mr. Watson?
Double checking my own math right now, Your Honor. Thank you. Only be a moment. Your Honor, I believe that to be accurate. Thank you.
All right, then I will make that change. And any other changes for the people to the report itself?
Not to the body. Thank you, Your Honor.
Okay, and then you want to take the changes to the guidelines?
Yes, thank you, Your Honor. Beginning with the prior record variable scoring, specifically PRV number 4. PRV number 4 is currently scored at 20 points. I double checked this a number of times. I only counted 2 low severity juvenile offenses, which would warrant 10 points, not 20.
And you agree with that, Mr. Watson?
Yes, I do, Your Honor. Thank you.
All right, and then do you have any more, Mr. Stevens?
PRV number 7 is currently scored at 10 points. And the people believe, based on just the convictions out of Isabella County, that should be 20 points for multiple, more than 2 concurrent or subsequent convictions. So PRV should be, PRV 7 should be 20.
Mr. Watson?
I have no disagreement with that, Your Honor. Thank you. And it does not affect the total PRV score nor the PRV level.
So I'm getting a, oh, you're right, it doesn't. It comes up still to 125, right?
Correct.
All right, and then how about OVs? Are there some changes there?
There, I have 4 changes. First is OV number 3. OV number 3 is currently scored at 0 points. It is the people's position, based on both the statutory language of the offense variables and People versus Houston, which I know this court is aware of, that OV3 should be scored at its highest maximum points allowable, which would be 25 points in this case.
Mr. Watson?
Your Honor, I've reviewed People versus Houston, and I've discussed this with Mr. Stevens and done my own exploration concerning this. And I have no disagreement with the scoring of 25 points for offense variable 3. Thank you.
All right, and your next one then, if there is one, Mr. Stevens?
Thank you. People would move the court's attention to OV number 5, which is psychological injury to victim's family. I believe that there is at least one statement in the pre-sentence report itself that would support some psychological injury to a family member. I also know that the court has received some materials from family members that indicate that they are seeking psychological counseling as a result of this matter. And then I also have to the extent the court or Mr. Watson would like anything further on this matter, I intended to provide a statement on behalf of a victim that I think would further support that as well. So with that, the people believe that OV5 should be scored at 15 points.
Mr. Watson?
Your Honor, I don't have any disagreement with that, and for reasons that I'll discuss later, I certainly can appreciate the what it is Mr. Stevens has pointed out. I personally don't need further proof of this, but Mr. Stevens, if he has that to offer, certainly he may.
All right, next one, if there is, Mr. Stevens.
Thank you, Your Honor. I will, the next one I want to address is OV number 6. OV number 6 deals with the offender's intent to kill or injure another individual. Now, it is currently scored at 25 points, which is certainly the mental state as it relates to the sentencing offense, second-degree murder. And I have discussed with this aspect with Mr. Watson. However, if you certainly look at the facts present in the record evidence, that being the sentencing report, it would warrant a scoring of 50 points with the premeditated intent to kill. So I will defer to the court's discretion as to the scoring of OV6.
Your position, Mr. Watson?
My position, Your Honor, is that it should be scored at 25 points based on the convictions. Thank you. Let him in. On the record.
I don't suppose, Mr. Stevens, that you have any legal authority for the scoring the way you're suggesting of OV6?
Other than simply looking at the facts facts surrounding and supporting what is being scored in the variable, that the court is to look at the true nature of the offense. I will say for the court, and in response to Mr. Watson's response, ultimately, though, this change would not change much of our total OV.
Well, I appreciate that, but I still want to score things correctly regardless. I have great hesitation in assessing the 50 points for premeditated intent to kill on OV6 based on what I have here. That is not typically, I know it says that you can score it that way. That is not typically and in practice how OV6 is scored on a second-degree murder sentencing. And with no guiding authority other than, of course, it's statutory, it's the statutory language, but with no other guiding authority, I am going to decline to score the 50 points on that and keep it at 25 as the probation department had scored it.
Thank you, Your Honor. And the last change that I would have, I will direct the court's attention to OV9. OV9 deals with number of victims. Now, in this case, admittedly, Mr. Gardenhire pleaded guilty to 2 separate counts, one for each victim in this case. And whether it is particularly described in the PSIR or not, what had transpired was Mr. Gardenhire shot and killed each of the respective victims in this case. The circumstances of which, though, are both victims were in the same apartment when this happened. It's the same transaction. This is admittedly, on behalf of the people, an area of the law that is at times in flux. But I would say that there is some authority that suggests that if multiple people are put in danger of bodily harm in the same transaction, that those respective victims can be scored correspondingly on OV9. That case law that I'm referencing is People versus Sargent. It's 481 Mich 346. It's a 2007 case. I can actually quote some of the language. So again, I'll defer to the court's discretion on this one. And I think Mr. Watson and I did in fact discuss this one as well preceding today's date.
Mr. Watson?
Your Honor, it is true. Mr. Stevens and I did discuss this People v. Sargent issue as it relates to offense variable 9. My position on behalf of Mr. Gardenhire is that it is scored accurately at 0 points presently. Thank you.
Well, you're both challenging me today unexpectedly. I think the argument is that they're 2 separate convictions. If we were sentencing one by itself, you'd score 1 victim for one and you'd score 1 victim for the other. But on the other hand, the court always is sentencing and scoring guidelines based on the entire transaction. And if they're part of the same criminal transaction, it seems to me that it's well supported to count it as 2 victims and scored 10 points. So I'm going to change OB9 to 10.
Thank you, Your Honor.
Thank you, Your Honor. I do not have any further changes to the guidelines. I just want to calculate.
Okay, I'll add them up here in case no one did that. I don't know.
I came to 130.
Just double check. I came to 130. And then what level is that, Mr. Stevens?
It's a 3. And it does change the range when we get there.
I'm there, so it looks like 365 to
600.
Okay, I've made that change. So now we've got guidelines that are level F3 with a recommended sentencing range of 365 months to 600 months.
People believe that is accurate. Thank you.
Okay, and we will then turn to whether there are victim impact statements. Mr. Stevens?
Thank you, Your Honor. I know there is one that's already a part of and made a part of the pre-sentence investigation report. Again, I know that a number of other materials have been provided to this court. I am here to provide a impact statement on behalf that has been supplied to me on behalf of Harley Owen's daughter, Zoe, and it reads as follows. He took away Zoe's dad at a point in their life when they were finally able to develop a relationship. I'm thankful for the time they were able to have, but it was only just the beginning. She'll never have a dad to walk her down the aisle or share accomplishments with. They can no longer talk about music and send goofy pictures. It has left her empty and broken. And that concludes the impact statement on behalf of Harley Owen's daughter, Zoe.
Thank you.
And it is my understanding, while there are a number of victims and or family members present, we have not been specifically notified if anybody is going to will be providing any verbal statements today, but I guess I know the court has allowed them in via Zoom. If that's changed, just turn on
If
their,
anyone does wish to speak, please unmute yourself and let me know.
thank you, Judge.
I don't see that anyone is.
Your Honor, I'm here physically, and Kelsey, I'd like to say a few words.
Yes, please come up, ma'am, to the podium if you would, please. Unfortunately, this big camera is not working, but I can, hold on. Okay, thank you for speaking up. I didn't know who you were here for. Come right on up.
Yes, thank you.
And you are what again?
My name is Teresa Kuhn, and I'm her aunt.
Okay.
And what I wanted to share is that we are the ones, my husband Jeff and I, that received the call from the police that they needed to speak with us and asked to come over and initially received the news. It's not ever something you want to have happen in your life. Get myself together.
Okay, just take your time.
Kelsey had been trying to turn her life around. She had tried so hard, and I think this last time was after her grandfather passed away. She was extremely close to her grandfather, and I think that was very difficult for her. And I just wanted the court to know she has a family that loves her. We prayed for her. We prayed for her life to turn around, and she was working on it. She has a son that he will never have a chance to be reunited with his mother, much like the victim impact statement that was just read. He'll never be able to see her as he grows up, and he was only 6 years old, very, very young. And we did have a memorial for her, and her family was there. Friends from high school came to her memorial. She is buried with her mother and her grandparents and another one of her aunts and her family. And I just ask that she be remembered here as a person, not just someone that might not have been doing the right thing at that moment in her life, but that she receives justice, that her family receives justice, that her son receives justice. And I ask that this person that could so easily take 2 lives, not just one, but 2 lives at the same time, as they're, my understanding, kneeling and shot in the head. I just don't see how anybody like that could be let back out. And I just ask that he is sentenced to the maximum that you can sentence him. And we love Kelsey and ask that in her memory.
Thank you very much for being here today and for your comments. And I'll ask again if there's anyone else that wanted to give a victim impact statement. And did the people wish to be heard?
Thank you, Your Honor. I'll be brief. There's 2 points I want to address. The first one is to really thank all of the family members of the victims. I want to thank them for their patience, for their support, and more importantly, as the court has seen today, both via my words, but via the words of Teresa, their voice for these victims. And then the second point, which will be brief, is frankly, Judge, there's no really other way to say this, but Mr. Gardenhire is an unapologetic murderer. He deserves to spend the rest of his days behind bars, and whether it's through the sentence of this court, it will certainly happen by way of sentence from Isabella County. That is what he deserves, and that is where he should stay for the rest of his life. Thank you, Your Honor.
Thank you. And Mr. Watson.
Your Honor, to Mr. Gardenhire's credit, he was eager to receive the offer in this case, to accept responsibility for what it is he did and to offer his plea. Anything better than that, Mr. Gardenhire may have to say. I can tell you that, of course, hearing a victim's family member, loved one, speaking about this reminds me of the fact that it's cases like this that don't just take a life, but that affect the lives of so many other people as well. Mr. Gardenhire has taken responsibility for what it is he has done, accepted a plea offer. I ask merely that Your Honor would abide by the Killebrew agreement as it's indicated in the pre-sentence investigation report. Anything further, Mr. Gardenhire can best say. Thank you.
Okay, and I just want to confirm to avoid, and I'll get to you, Mr. Gardenhire, but I want to confirm to avoid even the smallest of error that the Killebrew agreement, it was suggested at the time of the plea he would be a E3, 315 to 525 months, but the agreement was that he would be sentenced within the appropriately scored sentencing guidelines. So obviously we've changed those, and I may sentence him within the new scored guidelines the way we scored them today and still be within the Killebrew agreement. Is that correct, Mr. Stevens?
The people's understanding, yes.
Mr. Watson?
That is the defense's understanding as well. Thank you, Your Honor.
Thank you. Now your turn, Mr. Gardenhire, if you wish to say anything.
No.
All right. Well, this is absolutely horrific, and I have few words that could ever express how horrific this is, how deeply it has hurt so many people. I won't address Mr. Gardenhire. I'll just say that no one, absolutely no one, has to explain or support Kelsey because of any kind of a lifestyle or anything of that sort. It matters not one little bit. Kelsey was loved and well loved, and a human being as Harley as well, and there is no justification, there's no rationale, no rational human being could ever justify this. It is simply, as I said, horrific. And I will follow the Killebrew agreement to sentence Mr. Gardenhire within the appropriately scored sentencing guidelines. I know it is of little impact considering his Isabella County sentence, but I only hope that just to be here, whether in person or on Zoom, for the people that Mr. Gardenhire has hurt so deeply, that it at least has some kind of healing or therapeutic effect for people. So with that, I will order you to pay $130 to the Crime Victims Fund, $136 in state costs to the county, in the amount of $500 based on the state court administrative office calculated average cost of a criminal case in Ingham County. And Mr. Gardenhire is committed to the custody of the Michigan Department of Corrections for a period not less than 600 months, nor more than 1,500 months. He receives credit for 134 days already served. Mr. Gardenhire, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. You do that with a form called appellate rights, and you should just know, we'll get a copy to you in your hands if you don't already have it. You should just know the 42 days starts running from today's date. And you are all set. That will conclude the sentencing, and Mr. Gardenhire is remanded to the custody of the Michigan Department of Corrections.
Your Honor, will the court be sending the appellate rights form to Mr. Gardenhire?
Yes, I left it open. Sometimes the defense attorney sends it in advance, but we will make sure that it gets to Mr. Gardenhire.
Thank you.